The Supreme Court of Ghana has set aside a decision made by a high court requiring that a rerun of the election in the Kpandai constituency be held. And what actually happened in court? Mr. Nyindam and Mr. Wakpal were both candidates at the December 7th, 2024 elections on the tickets of NPP and NDC respectively. After the election was held and collation was done, Mr. Nyindam was declared the victor. The people of Kpandai had spoken, or so it seemed. On January 25th, 2025, Mr. Wakpal, aggrieved, filed an election petition at the High Court in Tamale, arguing that the election outcomes were fraught with irregularities in at least 41 of the 152 polling stations. He prayed that the court order a rerun and prevent Mr. Nyindam from having access to parliament. After hearing the case for nearly 11 months, in November 2025, the High Court ordered a rerun of the entire election. The judge was convinced that the irregularities were too grave to ignore. Mr. Nyindam was aggrieved and invoked the supervisory jurisdiction of the Supreme Court to quash the ruling on the fundamental issue of jurisdiction. He contended strongly that the petition was filed outside the 21-day period required by law, and so the High Court had no authority to determine it. The court had no power from the very start. Mr. Wakpal's case before the Supreme Court was founded on fraud and acquiescence. He argued that Mr. Nyindam had deceived him by claiming the results were gazetted on January 6th, 2025. Relying on this, he discontinued an earlier petition filed on December 23rd, 2024 because it seemed premature. The law requires challenges to come after the gazette, not before. Mr. Nyindam had tricked him into filing out of time, and this, in his view, was fraudulent. Apart from this, he argued that Mr. Nyindam had participated in the proceedings for 11 months and therefore had consented to the High Court's jurisdiction. Mr. Nyindam's case was simpler. The gazette notification was on December 24th, 2024, Christmas Eve. Mr. Wakpal filed his petition on January 25th, 2025, way outside the 21-day period. The Supreme Court assumed jurisdiction. Its supervisory jurisdiction is an exceptional one. The court exercises oversight on all courts in limited circumstances, where a decision is made out of jurisdiction, in excess of jurisdiction, with a clear error of law, or there's a breach of natural justice. It is not an appeal, and the court looks at how the decision was made, not whether it was right or wrong. The Supreme Court examined Mr. Wakpal's arguments. The court struggled to sympathize with his claim that he was deceived. First of all, it was his duty to ensure that the court's jurisdiction was properly invoked as a petitioner. Further, whether the gazette was December 24th or January 6th, his earlier action filed on December 23rd was still too early and he had simply jumped the gun. Additionally, even though Mr. Nyindam had participated throughout, you simply cannot give a court authority by showing up when the law says the court has no authority. Participation in and of itself does not cure a fundamental defect like that. But which gazette was valid? December 24th, 2024 or January 6th, 2025? Everything turned on this. The court ruled that the earlier gazette was a valid one. If later publications could reset the clock, institutions would manipulate deadlines at will. The petition should have been brought by January 14th, 2025, but it came on January 25th, 2025, 32 days after the valid gazette. The High Court was simply without authority, and the judgment was therefore a nullity, and accordingly, it was quashed by the Supreme Court. However, the dissent of Justice Puamang is notable. He took the view that to grant the quashing order would be manifestly unfair. Mr. Nyindam had participated actively, he had led evidence and made submission all the way to the conclusion of the case. Even the Electoral Commission raised no objections. The objection to jurisdiction came only after the verdict went against him. If Mr. Nyindam had won, he would have been celebrating. Perhaps it is only because he lost that he brought this action laden with technicalities. You cannot play a game, lose, and then claim that the referee had no authority to begin with. In his view, the law should not be used so slavishly so as to exclude people who have genuine grievances which have been found to have weight on the merits. Election petitions are one of our democracy's quality control mechanisms, and they should not be defeated on technicalities, especially not when the irregularities have been found on the merits to have been real. Mr. Nyindam could have filed an appeal to reverse his findings, but the proper course was not to extinguish the proceedings entirely. Now, what do you think? Follow Super Law G Studios for more.
Real stories, real cases, real people.